Hello, and welcome to yet another episode of Voice the SASHA PoSHcast, your go-to podcast for all things posh. I am your host Shweta Bhatt, and in this episode, we will look at a pertinent question that we have seen employees, managers, HR employees, and internal committee members ask us, and that is, in what scenarios does the internal committee or the PoSH committee not have jurisdiction? Where can the IC or the internal committee initiate inquiry and where can it not? In order to take us through this topic, we have advocate, PoSH consultant, external member, and veteran SASHA team member, Srividya Sriram. Srividya will run us through a few of the scenarios where the committee might not have jurisdiction and what the employer can do about it. After this, Srividya and I will talk about some of the frequently asked questions that people have on this topic. Without further ado, let's dive in.
Hello all, I'm Srividya Sriram. I'm a member of Team SASHA. In this episode of PoSHcast, we will be speaking about the scope of the jurisdiction of the internal committee in prevention of sexual harassment at workplaces. There have been multiple times we come across instances where an anonymous complainant seeks redressal. Sometimes the perpetrator is an outsider, and other times when a male employee or an employee of the third gender approaches the committee. Now, considering that these concerns relate to sexual harassment, the questions that come to our minds would be whether the internal committee can look into these matters. Under the prevention of sexual harassment of women in workplace, any organization with 10 or more employees needs to nominate an internal committee. This internal committee has the limited powers of a civil court to inquire into complaints of sexual harassment. In our discussion today, we shall look at the scope of these concerns and the powers of the committee in resolving such complaints that are not within the jurisdiction of the internal committee. Now let's take an instance where a manager asks his male team members for drinks late in the evenings. The conversations during these social gatherings revolve around the ongoing project. The female team member feels isolated and believes she was put at disadvantage because she could not participate in these discussions. When the manager is spoken to, he feels that it's inappropriate to call a female member for drinks outside. Now, would this qualify as a grievance of sexual harassment at workplace? The guideline for the internal committee to formally initiate an inquiry is to gauge whether the inappropriate conduct is unwelcome, sexual, and has occurred in relation or connection to a workplace. If complaints do not have the above component and the impact seen is not due to a sexually wrongful conduct, then these can be identified as workplace issue or discriminatory practices, and such concerns can be forwarded to the employer for further appropriate redressal. Now, the reality is that men and other genders do face similar sexual harassment at workplace. The law, however, is gender specific and its applicability would be for women employees. Many organizations do choose to keep the policy gender neutral and have similar redressal processes for complaints by employees of all genders. Under the scope of this legislation, however, the redressal is only for women employees. Grievances raised by male employees or others get addressed by the grievance redressal process of the organization. When a complaint is time barred, the IC cannot initiate an inquiry. The Act allows a period of 3 months for a complainant to raise the complaint, and the IC has a power to extend it using its discretion by another 3 months. This is also one of the challenges that the Me Too movement face. If a complaint is raised beyond the set timelines, this could then be addressed under the grievance redressal process of the organization. Now, adjudicating anonymous complaints can be difficult for the committee. The Act requires a formal written complaint to be filed. In addition, following principles of natural justice, the respondent has a right to know who has raised the complaint, what are the specific charges against him, and has an absolute right to defend himself in the process. Therefore, the committee cannot inquire an anonymous complaint. Let's take an instance where a complainant walks up to the IC, shares her grievance, but is reluctant to file a complaint. This could be due to multiple reasons. Complainant is fearful of the repercussions at work, she seeks anonymity, and sometimes it's just that the complainant perceives a lot of duress which creates doubts in the complainant. Now it becomes imperative here that the IC assures the complainant, builds trust, and gives her the confidence to formalize the grievance. If the complainant is still unwilling to do so, in the absence of a formal complaint, IC cannot suo motu investigate the grievance. Whatever be the decision of the complainant, it is important that the IC documents the same and shares this with the complainant. This mail should also have a reference of the policy and reiterate the message that she could reach out to the IC anytime in the future if she feels uncomfortable. Now, when there are scenarios where there is a formal complaint, but the complainant is unable to identify the respondent, IC can try and identify the respondent with the assistance of the employer. If the respondent still remains unidentified, then the grievance cannot be redressed by this committee. Similarly, if a respondent is an outsider or a third party, then the employer or the IC does not have a direct control over such person and hence cannot take this ahead as a formal inquiry. One of the biggest challenges for the committee is when instances happen in the personal capacity of parties. In one instance, a group of team members went out for a weekend trip, and at the venue, a male employee exhibited certain sexually inappropriate conduct with his female colleagues. Now, in this case, the said concern prima facie may not seem to have a workplace connect. The manifestations of sexual harassment as defined under this legislation clearly includes circumstances which interfere with the work of the complainant or creates an intimidating, offensive, or hostile work environment for the complainant. Therefore, if the IC has a reasons to believe that the violating behavior comes back as hostility to the complainant at the workplace, then the IC can proceed with inquiring the grievance. The intimidation, of course, would be much stronger if the respondent holds a power position, in which case there is a definite case for the IC to look into the grievance. If such a circumstance is not presented, then the IC does not have powers to take this ahead under its jurisdiction. As a right practice for closure, it is recommended the IC should ensure due documentation is followed in such cases, and communications for closure should also be shared with the involved parties. In addition, this committee has a preventive role, and whatever grievances that cannot be taken ahead for redressal by the committee should be forwarded to the employer for further action. I'd like to close by saying that the law has vested the internal committee with wide discretionary powers. The committee, therefore, should exercise due caution, and it is essential that there is a clarity on the scope of the jurisdiction of the IC. Thank you.
Thank you, Srividya, for that presentation and for doing this Q&A session. We are very happy to have you here.
Thank you, Shweta.
So I have a few questions that were asked by Team SASHA, and I'm just going to run you through those questions. These are all questions which are related to specific scenarios that they have asked, whether the internal committee has jurisdiction or does not have jurisdiction, and why. Most of these questions are around that. So let me just begin. So the first question is about a complainant who has gone to do an interview at an organization. So the complainant states that she was subjected to sexual harassment, and the allegation is that the interviewer asked her personal questions during the interview. So should the committee initiate inquiry in this case?
So Shweta, what kind of personal questions are we talking here? So in one of the cases we had, the interviewer asked questions like, do you drink? Do you smoke? Now, these kind of questions may be violating personal boundaries. However, if there are specific questions like, do you have a boyfriend? Would you like to wear Western clothes to work? Do you go drinking over weekends? Now, these could be attributed to be sexual harassment. In this current scenario, under the Act, an aggrieved woman can be employed or not, and if she has to be a complainant, then the alleged conduct should have been violating in relation to the workplace and should have sexual connotation. So in this particular instance, I would say that if the complainant has come for the interview to the workplace, she's been called, and the conduct, of course, is has sexual connotations to it, then we could say that this is something that can be brought under the purview of an IC inquiry or a committee inquiry.
Moving on to the next question. So you mentioned that the internal committee does not have jurisdiction for anonymous complaints. So if a complainant wants to, can the identity of the complainant be protected by the committee?
Act does not allow for protection of identity of complainant. Like we discussed, this process is aligned to principles of natural justice. Under Rule 7 of the Act, a copy of the complaint, of course, has to be shared with the respondent. So the scope for protection is not there. If under exceptional circumstances, say the organization, the committee goes ahead and gives such protection, this can, of course, be questioned in the appeal.
Okay, interesting. The internal committee dismiss a case because the last incident has occurred 2 years ago?
So for the purposes of this committee, the jurisdiction should, we entertain complaints which have been raised within 3 months of the incident having happened, or when there's a series of incidents, 3 months from the date of the last incident. If there is, of course, an exceptional circumstance of a trauma or something else that stopped the complainant from reaching out to the committee, then in that case we can extend it by another 3 months. But beyond this, we do not have the power. The complaint is barred by limitation. So most times in these cases, what we do is we ensure that this is then through the employer addressed by the grievance redressal of the organization.
Okay. The complainant has sent an email to the manager, and that is the complaint, and the manager has not taken note of it, not done anything about it. And later on, the complainant files with the committee, and by that time, the timeline to file a complaint has already elapsed. So in such cases, what should the committee do?
So the complainant has actually raised the complaint within the set timelines. The manager has ignored it, and we cannot hold the complainant responsible or time bar the complaint. The IC should condone the delay and take this up as a valid or a formal grievance and initiate inquiry. What the committee should also do is document the delay in the inquiry proceedings.
Okay. So will the manager, a follow-up question, will the manager will the committee then have to talk to the manager and ask as to why or hold the person accountable for not?
Absolutely. So what happens in scenarios like this is that the committee, in a way, in its preventive role, does reach out to the managers to understand why this was ignored. And then further sensitization should be accorded or should be done with the manager to ensure that these complaints are duly escalated or duly forwarded at the right time.
So the complainant alleges or files a complaint against a member of the committee itself. So in such cases, what should the committee do?
So in instances where there is a complaint raised against a committee member, the requirement would be for the committee member to step down, recuse himself, or the member may be requested to step down. Now, under Rule 7 of the Act, an inquiry should be following principles of natural justice. Now, what this means is the complainant and the respondent are allowed to report any objections they may have with respect to either the entire committee, the quorum of the inquiry, or one specific person. And this could be relating to presence of a bias or lack of fairness in the constitution of the committee. Now, in such scenarios, the employer has to take cognizance of the objections raised and reconstitute or nominate a new committee for the said inquiry.
Okay. So the person, the respondent, would then be recused from the committee before the inquiry begins, and a new committee is reconstituted to start.
Absolutely, yes.
Moving on to the next question. So the complainant, as we know, the aggrieved woman has a right to file a complaint with the police as well. So if the complainant has filed a complaint with the police, after filing a complaint with the internal committee, should the inquiry process still continue? Should the committee stop the inquiry? What do you?
So under this process, the complainant is allowed in her personal capacity to go ahead and file an FIR with the police for the exact same set of grievance. The employer will have to assist the complainant. It's a part of the employer's duty. The inquiry under this legislation is a disciplinary hearing to inquire into workplace related or sexual harassment violation. Now, a police complaint or an FIR is a criminal proceeding, and one does not preclude the other, which means that you could have an FIR and further investigation on that, and we could still continue to inquire this within the ambit of the proceedings in the organization. Now, the maximum penalty that can be accorded under this PoSH process, of course, is termination. However, if you are being, tried under the IPC section 354 A, then this could be, up to 3 years imprisonment, fine, or both.
So let's say that the aggrieved is unhappy with the manner in which she's raised a concern of discrimination in the workplace, which might not necessarily be sexual harassment. And with HR, and the HR is tried to do something, and she's not happy with the way that it has been handled by the HR, and that's why she approaches the internal committee. Can the internal committee do something to help her?
Unfortunately, no. Because we have a scope of jurisdiction. The aggrieved, of course, if there is an appellate mechanism within the organization, she can reach out to this appellate process for further, resolution of her grievance.
So basically, what you're saying is that if the organization has an appellate authority under the code of conduct policies for their discrimination and workplace harassment grievances, then the employee has a right to approach that authority. But the committee itself cannot, because it's out of scope of the internal committee's jurisdiction, is what you're saying.
Absolutely.
Why should the internal committee have clarity on jurisdictional aspects? I mean, why should there be this sort of a boundary? And what happens if the internal committee takes up a complaint outside its jurisdiction or initiates inquiry where it supposedly should not?
Right. There is an objective why this committee has been accorded these powers of a civil court, right, for adjudicating complaints. Now, when the IC exceeds its jurisdiction, it is acting beyond the scope of its authority. Now, this may not be fair on the parties. Like we said, the respondent has to know, or the complainant has to identify, and multiple such scenarios which we spoke earlier. Now, when the committee is acting beyond its scope, this is definitely not fair on the parties. And if in the event that this goes into appeal, this can be questioned in the appeal process.
Okay. Thank you so much, Srividya. That was a very insightful and enlightening conversation for me, and I'm sure to all our watchers. So in closing, is there anything that you would like to say?
So yeah, we have called out scenarios which does not have the IC jurisdiction, and I don't want employees or anybody, hearing this to believe that, oh, I have a lot of roadblocks here, and I have to cross a lot of issues to make sure the organization hears me. Clearly, that's not what we are trying to say. What still the act here is a power in the hands of a woman employee, which permits her in given defined timelines to request the employer to redress something for her. So my request would be speak up. It's important that you speak up. Let the organization decide whether it's a scope of the committee, it's a scope of a grievance redressal process, or how they should handle it for you.
Yeah, I think that's a great way to end the session. Speak up, and I think the more we say it, we can never say it enough number of times.
Absolutely.
That the aggrieved need to speak up, the victims need to speak up. Thank you so much. This was a great conversation.
Thank you so much, Veka.
And that was our episode, dear viewers. What did you think? What questions are you still left with? What comments do you have on this topic? Write to us at voice@sashaindia.com. We would love to hear from you. Also, don't forget to follow us on social media. We are on all major social media platforms. Until we meet again next month with a brand new topic under the subject of prevention of sexual harassment at the workplace. Take care, stay healthy, stay safe, and remember, prevention and protection leads to progress.